Welcome to A Levels Academy Islamabad. Today's topic is on the Acts of Parliament. Let's see the question. Discuss whether Acts of Parliament are always the most important source of law. Let's see the answer. It is a complex issue to determine whether Acts of Parliament are always the most important source of law. While they hold a unique and supreme position in the English legal system, other sources, particularly common law, have foundational and ongoing significance. So overall, in this first paragraph, it says that to determine whether the Acts of Parliament, first let me clear what are Acts of Parliament. Acts of Parliament means the laws that are made by Parliament are named as Acts of Parliament. So they're saying that are these Acts of Parliament important enough to be considered a source of law? So in my answer, I have written that it is a very complex thing to identify that these Acts of Parliament are important or not, because some of these acts might be very important, but the others may not be that much important. But these Acts of Parliament hold a very supreme position in English legal system. In simple words, it means that the English legal system itself is all made with the help of Parliament's laws. So the other sources that are like common law also have a very important role in making the English legal system. After writing about the paragraph, then you have to move on to the next heading that I have mentioned is on the supremacy of the Act of Parliament. Before diving to the paragraph, I want to clear what is supremacy. Supremacy means something that is very powerful, strong, and dominant. Nothing is superior than that. This is called supremacy. But if it's supremacy is written with Parliament, that means the laws made by Parliament are supreme, and no one can challenge those laws that are made by Parliament. Before starting, I just want to make sure to let you know that the Parliament itself in UK is the highest branch, is the most strongest branch compared to the judiciary and others. So if you think that it's about Act of Parliament, beside the acts, Parliament itself is the supreme one. So whatever Parliament does, whether making laws or handling the other matters, no one can challenge Parliament. This is the reason the Parliament in UK is really supreme. Even though their acts and laws are also supreme, the sources strongly support the argument that Acts of Parliament are the most important source of law due to the constitutional principle of the parliamentary supremacy. So I've repeated the same concept that I have discussed to you all, that the Constitution of UK itself declares that the Parliament is supreme. That is the reason I have bold this. You should also bold this with a marker while writing the answer. The principle establishes that an Act of Parliament can override any other form of law, including common law and previous statutes. So basically, the first point says that the Act of Parliament is strong and supreme enough that it can override or change or stop any kind of a law or any statutes. No other body, including the courts, has the authority to override or set aside an Act of Parliament. As I have mentioned earlier, that the Parliament itself is very supreme. Even if they make any law or Act of Parliament, obviously the laws they make, the laws Parliament make, is also named as Act of Parliament. So whatever they do, like making laws, those laws or the things done by Parliament cannot be challenged by any other department. Even if the other department is a court, it can also not ask questions by the Parliament to know that why you made these laws, should these laws be executed. So the courts itself don't have that much powers. That is why in the second point I have mentioned that the other body, which one? The other body is the court. Like the court is the branch or a body that functions in order to check other department as well. They do have this power. Like this power is called as judicial review that is given to the courts. Even though the courts have the judicial review power, still the courts cannot set aside any act of parliament, nor do they can override those acts. In the last point I have mentioned, laws passed by parliament cannot be challenged through judicial review. So as I have mentioned earlier about judicial review, that the courts do have the power of judicial review. Judicial review is a power in which the courts can check any other branches. So even with the help of judicial review, those laws that are passed by parliament cannot be challenged. Now we will move on to the next paragraph. This supremacy is so profound that it can be seen as conflicting with the rule of law. Before explaining this statement, I want to clear about the concept of rule of law. So the rule of law taught us about 3 different points. First point says that law is supreme. This is the concept of rule of law, that the law is supreme. This is the first point of rule of law. The second point of rule of law is that king must obey law. All right? And the third point, all rights should be protected. So these 3 points are highly considered and discussed in rule of law. But in this first statement, the supremacy of parliament does not go according to the rule of law. Why? Because even though the parliament is making any kind of law and that law goes against the rule of law, still parliament wins. Parliament is supreme. No one can say that parliament did this, parliament did that. So in easy wordings, I'm saying that the rule of law doesn't go according with the UK's supreme parliament, because the parliament is supreme. So parliament can do anything, like it can make different laws, it can even stop the king from doing different acts as well, because currently the parliament in UK is the strongest branch and the supreme one. While the rule of law suggests an absence of arbitrary state power, parliamentary supremacy grants parliament the right to create any law it chooses, which could even include granting arbitrary powers to government ministers. So as you can see, I have discussed earlier that the rule of law doesn't go along with the supremacy of parliament, because parliament can make laws that can give the government or the minister the control and can convert the powers into arbitrary powers. So if you don't know the concept of arbitrary, let me make it easy to you. Power under one person, like if there's all the power given to one person, we all know that the powers, if they're given to one person, that person can misuse his powers and can become injustice. This is the reason people do not like arbitrary control. Always people recommend to have distribution of power in different branches so that no one can be supreme. But parliament itself is a supreme branch. It can give power to its ministers by making laws that can be arbitrary. That's the reason they said that rule of law is not much followed in UK. And this is the whole concept written in this paragraph. Furthermore, the scope of statutes law is greater than that of the judicial decisions. From this statement, we can also say that the statute laws are more greater in value than judicial decisions. Statutes laws are basically made by parliament. That is the reason these laws have more value than judicial decisions. Judicial decisions means the decision made by the courts by the help of judges. So judicial decisions are not much stronger than the laws. Judges can only create new law when a specific case is brought before them, and their ruling is limited on the point in that case. In contrast, acts of parliament can make wide-ranging changes to the law or set penalties, a power that judges do not possess. So in this last statement, we are cleared with the concept that judiciary can use judicial president in order to make a little bit of new laws. But obviously, judiciary doesn't have a full power like parliament has. Parliament can make different changes to their laws. Parliament can add different punishment in their laws. But judiciary cannot do that. This is the reason parliament is more stronger. This is why the statutes that are made by the parliament are more valuable compared to the judicial president. Alright, now we will see few examples. Examples of parliament's power to shape significant areas of law include: number 1, defining criminal offenses, such as the theft through the Theft Act 1968. Before starting the others, I want to clear that if any person out there commits a crime, and before committing a crime, if he or she wants to know what kind of punishment they would get if they commit any kind of a offense, so what they will do is to read all the punishment that is mentioned in the Theft Act 1968. Who made this Theft Act? Obviously Parliament made it. Parliament made this act. So Parliament have mentioned all the crimes and their punishment in this Theft Act, that any person who commits theft in any kind of a way, they can be punished and can be fined as well. So from here we can see one example of acts of parliament. Let's see another one: providing consumers protection through the legislation like the Consumers Right Act 2025 and the Unfair Contract Terms Act 1977. So basically this portion discusses about the consumers protections and other contract related matters. Then we have intervening to the correct perceived injustice in common law, as seen with the passage of the Contract Right of the Third Parties Act 1998. So this is the act that was made during the year of 1999 or 1998. And in this act, Parliament discussed about the intervening to correct perceived injustice in the common law. Like obviously if common law had a bit of mistake in it and is causing injustice, then that injustice can be corrected by the help of this act. And who made this act? Obviously Parliament did. Let's see the other example. Enacting major constitutional changes such as the Constitutional Reform Act 2005, which enshrined the independence of the judiciary. So basically this act that was made by Parliament gave more independence to the judiciary, like the courts. Courts got more independence after the creation of this act by the Parliament. There are more examples of different acts as well, but I have mentioned only these because these acts play more vital and important role. Alright, now we will move on to the next heading: the enduring importance of the common law and sources. Despite the supremacy of Parliament, the sources indicate that other sources of law are also critically important, challenging the idea that Acts of Parliament are always the most important. Alright, in this statement, I have discussed that the supremacy of Parliament is obviously the main thing, but we cannot ignore the other sources of law as well. So the first one is the common law as the foundation. So from here you can see the other sources are being discussed. So the first source is the Parliament. So remember, Parliament is the main source that makes laws and also write down the punishments as well. So remember, Parliament is the main source, and the others such as the common law and the other ones are gonna be the other sources, and they also are important as well. English law is fundamentally based on common law. Obviously the English legal system, or if we're talking about the England and Wales law, common law plays a very important role there, which is unwritten law developed over centuries from the customs and judicial decisions. Obviously the common law didn't develop quickly. It took a lot of time, a lot of centuries to be created. And how it got created, it created with the help of customs and judicial decisions. I also had explained this in my first video related to the topic of customs and judicial review. You can also check them out from my previous video that is mentioned on my channel. Following the Norman conquest, judges traveled the countries and gradually selected the best local customs, making the law uniform or common across the nation. From here, I've already discussed this in my previous video that I've mentioned that what is the meaning of common law? Obviously, the word common itself indicates that that law is for a particular place where people are like the same and they're doing the same stuff and it's available for the same place. That's the reason the laws that are being used there are kind of like common. That is why those laws are named as common law, because this common law is being widely and highly used in that particular area. So I have already mentioned that in my previous video. I've repeated it here as well. This historical development means that many fundamental legal principles originate not from Parliament but from the judiciary. One of Professor Dicey's element of the rule of law was supremacy of ordinary law, which he noted was particularly true in his time, as many key developments had come from judicial decision rather than Parliament. So basically, if you do not know about Professor Dicey, he's a British jurist and has a high knowledge related to the Parliament supremacy, rule of law, and also about separation of power as well. Alright, so he told us about the concept of rule of law, that ordinary laws other than the laws made by Parliament, the other ordinary laws are more important. Why? Because Parliament had made many laws after those laws which were already created with the help of judicial president. Alright, this is what is mentioned in this paragraph. And what is mentioned in the first paragraph, you might be thinking. So basically in this first paragraph, it says that Parliament itself did make laws as well. But there are many laws that were already created by judiciary. So what had actually happened, because laws existed because Roman and the other countries like France and Rome, they also made laws as well. So obviously the UK people, the England country, collected these laws and then made their own laws. But Parliament cannot understand for what case what laws should be made. So those laws that were made by Romans and France people were being used by the judges. And when they were using these laws, then the case becomes the president. And with the help of that president, the Parliament made different laws for UK. So this is the reason the Parliament did make laws, but the judges had made the laws before than Parliament did. Obviously, Parliament themselves created laws, but obviously it cannot create laws instantly. It cannot understand the needs instantly. So the judiciary knew what type of case it is. It kept on giving judgments according to the latest case. This is the reason judiciary was more important. Okay, even today, judges can still create new laws through their decisions in court cases, which then become the law for future cases. So in this statement is very easy. I don't need to explain it. It says that judges of the judiciary branch can create new laws with the help of their previous cases as well. What are previous cases? Previous cases are named as precedents. Precedents is more like difficult to understand. That's why I use the name of previous cases. So if there are already previous cases made on the similar case that had appeared today, and it already had a solved case in the past, so judges use the past case and their decision on the new case as well. But if there's a very unique case had never been decided before, at that time judges use the previous precedents and also some different laws and custom to solve that new case. And when they solve that new case, that case ultimately create a new law. Then we have the next heading on rule of law. So before starting, we'll just read the last paragraph. Significant areas of law remain governed by common law. For instance, murder is common law crime and has never been defined in the Act of Parliament, unlike theft, which is statutory crime. So basically in this portion you can see that the common law had made the concept related to murder and crimes as well, but the theft concept had made with the help of Parliament. That is why the theft is named as a statutory crime, whereas the murder is named as common law crime. This is a difference because this concept of murder had appeared long ago, and Parliament didn't make any laws related to murder at that time. That is the reason this concept of murder was introduced by normal law. Later on, Parliament made laws on theft. That is why theft is named as statutory laws, because they are made by Parliament. Then we have the role of custom. Historically, custom was a primary source of law and formed the basic of English common law. The 17th century law Justice Coke described customs as being one of the main triangle of the law of England. While it is unlike to create new law today, its historical importance as a foundation of common law cannot be overlooked. I've already explained about custom in my previous video. If you didn't watch that, you might don't understand it from here as well. So let me explain it to you again. So what is custom? Custom is like the old practice or tradition that people follow in a particular area. Let me give you a more easy example. Suppose Muslim always celebrate Eid. Alright? Same way Christians celebrate Christmas and different events. So this is kind of like the same for the custom as well. Like a particular place follow a custom, and from the help of customs, judges can easily solve that case. How? Because that particular place has a specific custom, and with the help of those customs, judges can solve the case of those people that belong to that same place and having the same custom. This is why custom played a very important role in making the laws. So in the past time in the history, custom was considered the main source of law, but obviously over time things have changed, time have changed faster. So the custom is now not much used, but in the past it was the main source to make laws. Even though the Justice Law Coke also mentioned that the customs is like a triangle in creating the source of law, like custom, president, and some other legal researches. All of this made laws for England. This is why the judge mentioned that the custom is one of the main triangle in creating the laws of England and Wales. Now we will move on to the next heading is on the judicial interpretation and checks on powers. Before diving into the paragraph, what does interpretation means? Interpretation means making something easy. You can also write this down as well. So interpretation means making something easy. So if it's about judicial interpretation, it means that the judges have the powers to make the laws in more easy wordings. So this whole concept is called judicial interpretation. Then what is checks on power? Checks on powers means that the judges have the powers to check other branches. While Parliament makes statute law, it is independent judiciary. It is the independent judiciary that interprets and applies. So basically, when Parliament makes laws, then if those laws are difficult to understand, then what do? Judges then interpret those laws to make them more easy so that any person out there can understand it easily. The courts also exercise a check on delegated legislation, statutory instruments, which are laws made by the government ministers, can be challenged in the court. So basically, here you can see they're not talking about parliament, they're talking about the ministers. So the ministers, if they make any law, these laws made by the government minister can be challenged by courts. Challenging by court means that the court can question the ministers that why you made these laws and for what reason. But these courts cannot challenge or ask Parliament because Parliament is supreme, as I have discussed earlier. But ministers, they can be challenged, like their laws can be challenged by court. This is called the power of judicial review given to courts to check other branches if they make any law that goes against the UK's constitution. Can be challenged by the court through judicial review to ensure the ministers has not exceed the powers granted to the. Alright. So the last portion they said that why do courts check these things, like why the courts check the ministers' laws and the things they do? Because courts make sure that the ministers do work according to the powers given by the parliament to them. Then we have conclusion. In conclusion, you have to add all the 4 points discussed earlier in a big paragraph. In conclusion, while acts of parliament are hierarchically the most important source of law due to the principle of parliamentary supremacy, It is not accurate to say that they are always the most important source in every contest. So basically, this in this conclusion, everything that is being repeated again that we have already discussed. But I'm just going to reread it again so that you can understand what is mentioned here. The common law provides the historical foundation of the English legal system and continues to be dynamic and crucial source of law today, with judges still able to create law, with major offenses like murder remaining defined by judicial precedent. The relationship is best understood as interactive. Parliament often legislates to codify, amend, or reverse developments in the common law, while the judiciary interprets and applies the laws Parliament creates. Therefore, while an Act of Parliament holds ultimate legal authority, the common law remains a fundamental and indispensable source of English law.